technical difficulties, we will be patient with you. And if we have technical difficulties, we hope you will be patient with us. The rules of appellate procedure that apply to oral argument apply to this format as well. Nothing has changed. You each have 15 minutes to present your argument, and there is no rebuttal in the Massachusetts Appeals Court. I'm joined today by Justice William Meade, Justice Gabrielle Wolohojian. My name is Ariane Vuono, and we're ready to begin. I'll call the case. One moment. The first case on our list is City of Newton versus Newton Police Association, 2019-1599. Attorney Honey.
Good morning, Your Honors. May it please the court, James Lamond, on behalf of the appellant,
Yes.
the Newton Police Association. This case comes to us from a seemingly different era. We thank the court for its ability to adjust in this way. This involves a pay dispute, really, from 2017. It's a contract term that we see at issue, and it's found on page 34 of our record appendix. And it reads as follows: effective July 1st of 2002, each officer shall be guaranteed 4 hours of pay at the applicable detail rate for every detail lasting 4 hours or fewer. That's the relevant part. And 2 pages before that, on RA 32, we see the start of this contract term regulating paid details. And it makes plain that these are matters that are done on officers' off-duty times. The nub of this dispute came to be really how many details the officers in question worked on the particular day, 2 days as it turned out, that this case came to involve. Because the pay term has a trigger for 4 hours of minimum pay for every detail. That's what the parties really came to have a dispute about, as to whether these officers worked 2 details or had 1 detail assigned to them only. Their dispute went through the contract grievance process. It wasn't able to.
May I interrupt for a second? There's really no dispute, is there, that they did not actually work 2 details? That's not your position. Your position doesn't turn on whether or not they actually worked the 2 details, correct?
Yes, Your Honor. The measure is whether they've been assigned, and that's the theory that the arbitrator
the theory,
embraced.
Right. So, so I'm trying to understand what your position is with respect to provisions in the collective bargaining agreement and the statutory requirements regarding reasonable charges. So if, for example, in the CBA, they had agreed, the city had agreed to pay the officers for detail work $2,000 an hour. Let's just say that was in the CBA. How would we understand an agreement such as that to relate to, is anything that's in the CBA necessarily, quote, reasonable to be charged to the person seeking the detail or required to have the detail? In other words, is the CBA necessarily the measure of reasonableness?
Well, Your Honor, the CBA is the measure of what the parties themselves have agreed to under the strong public policy encouraging such agreement. The question, I think, Your Honor, is there some statute out there that such a term, if it were to be enforced, would come into direct and material conflict with? The city has pointed to one such statute, and that's the statute that Your Honor has just referenced. And the question is that designed by the legislature as a measuring stick for what cities can charge for their various services?
Well, whether or not that's the question, I guess, I'm sorry, because my question is really not well focused. So I appreciate you're trying to put a little bit of definition to it, but is the CBA the measure of what reasonableness is? So in other words, no matter what they agree, if they agreed that officers will, be paid the contractors I don't know, 5% of the contractor's profit on the job, or whatever, firstborn child, whatever, and some kind of wacky provision that they nonetheless agree to in the CBA, would that dictate what is, or bind the interpretation of what is reasonable under the statute?
Your Honor, I guess, well, I would respond this way, that really presupposes that the Section 22 is designed to be a measuring stick of public charges. A collective bargaining agreement is as you note, the compilation of the promises that the parties have made. Whether any one particular promise is sufficiently not a good idea from a policy standpoint that somebody might have a basis to challenge it, really is not the focus here, with all due respect, because the city has said, yeah, sure.
Isn't really the issue here in part whether Chapter 40, Section 22F prohibits cancellation fees?
I believe the city has said so, Your Honor, and yes.
But you don't agree with that. I mean, it doesn't. The statute doesn't say anything about cancellation fees.
It doesn't prohibit it, and the test that we find ourselves bound by is to look at whether the statute prohibits that contract term from being given effect. I believe that the way to look at 22F is not as a freestanding grant of authority to contractors, to vendors, to challenge assessments that cities and towns have made against them. Rather, it's the legislative path to distinguish the permissible from the impermissible. The statute itself is an exception to the general rule, and the rule is cities and towns can't tax.
Was there any cancellation fee imposed here? No, I don't think.
The record that came before the arbitrator was silent on the question of whether it had. The arbitration award certainly doesn't prohibit the city from charging such a fee if it wishes to do so. It chose not to do so in these circumstances and chose not to make a payment, but there's nothing in the arbitration award that would prohibit it from doing so.
Do you think the CBA requires that a cancellation fee be charged, or leaves that to the discretion of the department?
The collective bargaining agreement, as interpreted by the arbitrator and as applied by the parties without contest over the years since 2002, when that minimum guarantee came into play, it has been construed to require that cancellations within less than 2 hours of the start of the detail trigger the payment of the 4-hour minimum. That has come to be called a late cancellation fee, but it is a subspecies of the 4-hour minimum guarantee. And as we've pointed out, the record before the arbitrator contained evidence that the city has, without contest, regularly and routinely charged that fee in cancellations. The arbitrator noted in 2 instances that the city makes it plain to contractors before they choose to have a detail that if you cancel before 2 hours, you will get assessed the fee. So what we have is about—
did you have information in the record about reassignments as well?
So the issue of reassignment was presented to the arbitrator as one of dispute. The city said, we've done this before. The union said, you haven't, but even if you have, it's been on such a small number of occasions that we still retain the right to challenge it. And the arbitrator, in a decision that is within her power to do so, said that the union does have the right to challenge this, even if the city has, on a small handful of cases, reassigned people before and not treated it as 2 separate details. So we did have an issue teed up, if you will, for the arbitrator's consideration. And our position was it wasn't a historic practice to do that.
Okay, why is this a cancellation instead of a reassignment?
It is both. They were assigned the night before to their detail site, listed as such on the roster. They had that detail. The arbitrator had to decide, what do we call this transaction, this direction that you leave site A and go to site B? The arbitrator had to decide, as a matter of construing 6.2, 10. What do we call that? She called that a late cancellation. They had been then moved from one site to another. So we submit that that's within the realm of the things that the arbitrator was charged with deciding, how to name the transaction to then apply the language that the parties had agreed to. So
And
she calls
the
it
arbitrator, I'm sorry, the arbitrator said by not paying those late cancellation fees, the city had breached its obligation under the
So
contract.
the city's obligation in the detail context is to guarantee payments. The statute that oversees the regulation of this process sets up a method by way the vendors, the contractors pay to the city for the services. So there's this three-party arrangement. But in terms of what the city's contract duty is under the CBA, it's to guarantee the payment. They do that in two ways. They get the advance promise from a vendor that they're going to comply with all the obligations, which they notify them of. And then post the event, they charge them for the services. So
And the arbitrator, it's her duty to interpret what the contract means, what the CBA means, right? And
yes, Your Honor.
And she determined that in essence the question was what is a detail, and that if one is reassigned to a different detail at a different location, she concluded that was a second detail.
That's correct, Your Honor.
Yeah.
2 versus 1. That's what the nub of the dispute came
And the
to be.
result, excuse me, the result of that would be that an officer would be paid twice, one for the canceled detail and the one that's actually worked, potentially.
There will be 2 payments, and here's where I think the issue has to be clear. They're being paid for the cancellation. They've now worked a detail. They've been assigned to a detail that lasted 4 hours or fewer, whether they call it 6:55 or at 7:10, however this was arranged. That detail, the originally assigned detail, has now lasted 4 hours or fewer. As it turned out,
I'm sorry, and the city's only temporarily on the hook for that money, correct?
that's correct, Your Honor.
They pay and then they collect from in this case the Feeney brothers, who knew as part of their agreement that they had to pay these cancellation fees if they canceled with fewer than 2 hours notice.
We believe that's entirely correct, Your Honor. Nothing in the arbitration award prevents the city from doing that.
But could you just finish your answer? So in other words, potentially the officer would be paid for a detail that was canceled and a new detail that he or she was just reassigned to.
That's
the same
correct.
4 hour period, 2 payments.
So that is correct, Your Honor. And that's something that is done regularly and repeatedly, as the record before the arbitrator showed. When details are canceled around the time they start, 2 hours, that 4 hour fee has been triggered. It is often to the city's advantage to ask that officer, hey, will you go work this other detail that we have across town? It's uncovered right now. The vendor will benefit if you get to go work that detail. We'll benefit as the city because we will have covered that detail. But no one disputes that in that situation, at the end of the day, that officer has collected the 4 hours for the originally assigned detail and whatever amount of hours they have worked at the second detail.
Okay.
So Your Honors, that raised the issue of, is there something in either of the 2 statutes involved here that would prevent that outcome, that would make the arbitrator's declared award unenforceable, illegal, something the city simply couldn't do. In our view, is that there's nothing in 22F that would prohibit that from happening. We submit that there really is not a case to be had that a city has a freestanding grant to go in and challenge an award because the contract term they now determine to be unreasonable. There really is no case law under 22F involving anybody going into court challenging an admitted charge, an admitted fee as unreasonable. All of the court cases involve whether the charge is a lawful charge or whether it's an unlawful tax. So we think that the city has pointed to the wrong measuring stick and asserted the reasonable charge language in a context that the legislature never really intended. And again, I think I said earlier, we think the legislature intended that to be a method to help courts distinguish fees and charges, lawful charges, from unlawful taxes. The theory that this violates a Massachusetts public policy, we also think is not made out on these facts. There are a small handful of identified public policies in Massachusetts strong enough and clear enough to cause an arbitration award to yield. Most of them involve conduct cases, terminations for bad conduct. The small handful involving the anti-discrimination statutes really focus on whether the award would cause the city to come into conflict with a duty that it had. My time is running out. The argument that the contract itself barred this particular remedy, we think is without merit, and we would rely on the Plymouth Carver and Grobit and Super Radio line of cases. Thank you, Your Honors.
Thank you very much. Counselor?
Members of the panel, good morning. May it please the court. My name is Jeffrey Honig. I'm here on behalf of the Newton Law Department representing the city of Newton. So if I could pick up where counsel left off, I would say that the detail fee is a bit unusual in terms of how Newton goes about setting its fees, because typically our municipal fees are set through an ordinance process where the local legislature here, the city council, has an option, the ability to discuss it. It's typically done by a public hearing. Not infrequently, we have contractors show up as part of that process, and there's deliberation. This actually is set an entirely different way through the collective bargaining process, where contractors have absolutely no seat at the table. And effectively, when we send out police officers to these contracts, it's essentially an adhesion contract. If they don't like the terms of it, then contractors' only recourse is to simply not hire a police detail. So they are effectively left with whatever we set the detail fees and the detail arrangements.
Mr. Honig, the contractor is not a party to this case, right?
The contractor is not a party. That's correct, Your Honor. The contractor also has no involvement in the collective bargaining process. So
right. They're informed of the terms of the detail, including the cancellation fees, right?
That is correct, Your Honor. So
they make an informed choice if they cancel a detail with fewer than 2 hours notice, and probably see it as a cost of doing business.
Well, that is true, Your Honor. And the reason the city has an interest in this for two reasons. One is that these costs could potentially affect the city of Newton directly on public works projects, but also these types of costs.
But can I stop you there? The association, I think, makes a good argument that that's not the case we're resolving here, because this is a private contractor. So to say the city would be on the hook for paying cancellation fees on a public works project really isn't in play here. And more importantly, the city of Newton can control the city of Newton Department of Public Works. So they can put in any policy they want to prevent late cancellation fees on public projects.
Well, that is true, Your Honor. And this case does relate to the private payment of the fee. But as the Superior Court made clear, it's not clear from the arbitrator's award who actually is on the hook for the payment of the fee. So if it's the city,
the city's on the hook, and then as it worked in every other case, the city bills Feeney Brothers.
That is correct. So we have that process whereby we pass along the fee to the private contractor, and the private contractor arguably passes that along to the ratepayers. So it does have a potential effect on the residents of the city who utilize the utilities for which are being repaired, which is why these contractors are entering onto the public roadways in the first place. So the city's position is in this case is effectively the argument we made to the Superior Court, which agreed with us that the resulting fee has to comport with both the statute and also Emerson College. So any interpretation of the contract that leads to an inconsistency with state statute or the state case law is not a valid interpretation of the contract. And that's what makes this case so unusual, because it allows the arbitrator to come in and determine the validity of a municipal assessment. And the city felt like it had really no option but to challenge that, because you have a situation here where officers were receiving 12 hours of pay for 8 hours of work. And whether you characterize that as an additional fee, or our police chief likes to call it double dipping, because it has sort of a connotation.
But it does create a deterrent in the contractor from canceling late, does it not?
Well, in this case, it really wasn't so much a cancellation as it was simply a contractor taking an officer from a quiet street in Newton and putting the officer on a busy project on Washington Street, which needed further supervision by the police department. So, and honestly, these contractors can't always determine how many officers will sign up for a detail at any one given time. So that was an argument that the arbitrator made, that her advice to the contractors were to just engage in better scheduling. But sometimes it's hard to know how many officers accept details. We here in Newton have far many more detail opportunities than we have officers to actually fill them. So it's not uncommon for detail, particularly one in a very busy location in Newton, to go understaffed. From the officer's perspective, they'd rather work on a street.
I appreciate the practicalities that you're pointing out, but the fact of the matter is the parties here agreed to let the arbitrator interpret the terms of the contract, right?
That is correct, Your Honor. So
tell me how her interpretation violates Chapter 40, 22F.
Because she determined that these officers should be paid 12 hours pay for 8 hours of work. And the city feels that type of double payment, or as our chief likes to call it, double dipping, is not a fair assessment on these contractors.
How is it prohibited by Section 22F?
Because it's not a reasonable fee.
I think that if this was in a form other than an appeal of an arbitration confirmation, your argument might have some force. But we and for that matter, I'd suggest the Superior Court doesn't get to decide what's reasonable. If that were the case, then all CBAs under these circumstances would be subject to judicial review for reasonableness, would they not?
Well, this is an unusual exception. No, all CBAs, Your Honor, are subject to review by the trial court and the appellate courts of this state as to whether or not how it is applied comports with state statute and state case law. This case is a little bit unusual because it's not the traditional way municipal fees are addressed. So it is unusual for a municipality to be coming forward and saying the fee is not a reasonable fee. And it's the city's position that whether a fee does or does not meet Emerson College is a determination of law. And whereas an arbitrator has discretion to interpret the contract cannot be viewed or applied in a way that doesn't follow what the state law is.
And what is, in your view, what is again, Emerson College, again, a test of reasonableness?
It is. So Emerson College reinforces.
So it sort of comes down to the same problem. No?
Well, Emerson College does require that municipal fees be reasonable. It also requires that it cannot have the effect of raising revenue, or in this case, it actually raises revenue for the city, but it also enhances police pay in a way that the Superior Court found objectionable. So, and it also has to bear some reasonable relation to the amount of work performed. So in the past, when I've actually had to been on the other side of this equation and had to defend a municipal fee, I had to provide evidence to the court that, for instance, the time a building inspector takes to issue a permit justifies what a contractor thought was an outrageous fee. I think in one community, we assessed a $15,000 building permit, but we were able, through records and timesheets and things like that, to be able to convince the court that a $15,000 building permit fee is sustainable as commensurate with the work that the municipality put into it. When you
Mr.
have,
Honig,
yes,
I understand all of those policy considerations. And I think they obviously carried some appeal and force with the Superior Court judge. But the solution, why is the solution not renegotiation of the terms of the CBA next time around?
well, the CBA only applies to, the actual language of the CBA guarantees a 4-hour minimum to the detail officers. And that's really so that if you're living, let's say, out of this area and you come in to Newton to work a detail and you find that there is no detail to work, it's intended to compensate you for your time and effort of putting on your uniform, showing up to the detail. This was not a case, and I don't think the arbitrator found that this was a case of a detail that was actually canceled. In fact, in all of the situations on the quiet side street in Newton, the details actually continued. They just continued with a fewer number of officers. And
right. Are you saying so? Are you saying that the contract was explicit with respect to what happens when an officer is transferred from one detail to the other, as opposed to where the detail is entirely canceled?
The contract does not specifically address that.
Right.
However,
that's my question, which is, why isn't the solution a renegotiation of the terms of the CBA the next time around?
well, that's certainly an option for the city to clarify it. I mean, the city takes the position that when you have an officer collecting 8 hours pay for 8 hours of detail work, the officer did get a 4-hour minimum payment. This is not, none of these officers were financially harmed.
Well, the Superior Court called it a windfall, right?
That is correct, Your Honor.
But this is a payment that's specifically authorized by the terms of the contract. So I don't understand how that's a windfall. The parties negotiated this. This is covered.
Well, the city, as I said, takes the position that these officers were not financially harmed. They did get the 4-hour minimum call-in pay. It wasn't as if, and this does happen, where an officer will show up to a detail and either by some mistake of the city or some other reason, there's nobody showing up at the detail. And so that's a fair application of that section of the contract, then to pay the employee for the 4-hour minimum payment. But that's a different situation than the fact pattern that the arbitrator addressed to resolve the union's grievance, and certainly different from what the Superior Court addressed when the issue was taken up by her.
So two things. One, so I guess what you're saying is the arbitrator made a mistake about what was reasonable.
Correct, Your Honor. So the arbitrator really—
And is that something that can be reviewed under our narrow scope of review?
Right. So whether the arbitrator not only made that determination, but also the city's problem is in the remedy, which is that—
Okay, all right. Let's get back to my question. Are we able to substitute our judgment on a matter of what you claim to be a mistake in the context of an appeal from an arbitration confirmation?
You are, Your Honor, under Chapter 150C, if you conclude that the arbitrator ordered a remedy that does not comport with the law, either as it's set out.
Okay, but can we say there was a mistake in judgment, which seems to be what you're saying?
A mistake in judgment on the part of the arbitrator?
Yes.
Well, insofar as that mistake generated a bill that the city's going to have to issue to the private contractor or pay on the contractor's behalf, we potentially put ourselves in line for a challenge from the contractor, saying that—
But
maybe
that
that touches on my
didn't
second
happen.
part. The other part that I wanted to ask you about is you write in your brief that the city's at grave risk for lawsuits. I don't understand that.
Well, if whenever the city, whether it's however a fee is determined, issues a bill that is excessive, we put ourselves at risk to a challenge to that.
But Feeney agreed to the terms of this contract.
Well, Feeney really didn't have much of a choice. If Feeney wanted a police officer to work the detail, Feeney had to accept the terms. So the contract itself and the policies that the city have negotiated with both its unions, it's applied to Feeney without any consideration as to whether they agree with it or not. And that's really the very essence of Emerson, which says that if you're availing yourselves of a service of the city voluntarily, then you have to pay the fee. And because it has that flavor of being non-negotiable, I believe that the purpose of the state statute and Emerson is to assure the public who has to pay these fees that those fees are reasonable. And that's a question of law.
A question. You have 2 seconds. I have a question though. What aspect, you said that there's some aspect of the remedy that the arbitrator ordered that's unlawful. What aspect is that?
Well, the arbitrator ordered the city to pay the fee on behalf of the contractor, but the city, typically would just pass that fee along to the contractor. So there's no public funds available for paying for private contract work. It's essentially done through a revolving account. We front the money to the police officers, and then we send the bill to the contractor. It's the sending the bill to the contractor that the city has an issue with, but we also have an issue with paying for it directly for the reasons that are outlined in the brief, but also in the Superior Court decision.
Okay, your time is up. I'm just going to check with the panel to see if they have any more questions of you. See none. All right. We'll take the case under advisement. On behalf of the panel, I want to thank you again for participating in this format. And we hope that you and your family stay safe and healthy throughout the rest of this.
All right, we are live.
Okay, thank you very much. Good morning, counselors. I want to start by thanking you for participating in this remote format. I know there may be some technical difficulties, and I promise that we will be patient with you if you have them, and we expect that you'll be patient with us. So far, things have been going smoothly this morning. The same rules apply to oral argument on this format as I do in the courtroom. As you probably both know, you each have 15 minutes to present your argument, and there is no rebuttal. I'm joined today by Justice William Meade and Justice Gabrielle Wolohojian. My name is Ariane Vuono, and if you're ready to go, I'll call the case officially. Commonwealth versus Vincent VINCENT, 2019-1091. Counselor, you may begin your argument.
Thank you, Your Honors. Good morning, and may it please the court. My name is Tim St. Lawrence, and I represent the defendant, Vincent PHINIZY.
PHINIZY, thank you for correcting me.
Of course. This is a direct appeal from his conviction of assault and battery with a dangerous weapon causing serious bodily injury. There's one issue in this appeal, and we submit that under the SJC's decision in Commonwealth versus Herndon, that it was error for Officer Ferreira to testify to a prior alleged identification of Mr. PHINIZY as having produced a knife. This identification or alleged identification was made by his ex-girlfriend, Sylvie Gonsalves.
Let me ask you a question, if I may. There is no question that I'm referred to her by her first name, Sylvia or Sylvie. Okay.
Sylvie, yes.
Because there are more than one person with that surname. She was definitely asked, I think you would agree, whether or not she told the police that the defendant had stabbed Mr. Lucas, right? She was asked that question, whether or not she was asked on direct examination by the prosecutor, whether or not she had told the police that the defendant had stabbed Mr. Lucas, right?
That's right. She
and how different is that really from than what the officer testified to by saying that she told him that the defendant had produced a knife? I mean, you really can't, I mean, there was no question that the stabbing occurred with a knife. There wasn't a possibility that there was some other weapon involved, right?
Right, I think that's right. So the statement that you're referring to was a statement that she made to Officer Siarka.
Okay.
And I see your point that about the difference, and it is subtle, but I think it's important because the statement that she testifies, or the statement that she's asked about did you tell Officer Siarka that Mr. PHINIZY had stabbed the victim? That was
I don't
not.
think the question was that specific. I think it was just, did you tell the police? Am I correct?
That's
Okay.
right. That's right. It was the statement ultimately that she made to Siarka that
Okay.
she was asking about, but you're right that she didn't. The prosecutor didn't differentiate. So the question wasn't, did you see him stab, or did you tell the police that you saw him stab? So that never came out. And I think the argument there is that it's a supposition that she makes in that statement that she knows there's a stabbing because the victim is yelling that he's been stabbed and there's blood. So it's almost, it can be argued by defense counsel. That's a supposition she makes based on the circumstances that he's been stabbed and that.
Well, let me put the question this way, if I could. If the witness had been asked on direct examination by the prosecutor, did you say that you saw the defendant produce a knife? And she said, I don't recall that. I never said that, because that was her answer to just about everything. Then, of course, the testimony would have been perfectly fine, and there would have been no violation under the case law at all. Is that right?
Right. If she had,
Okay.
if the
If
question,
she'd been asked that question
yeah, if she was inquired directly
specifically.
about that statement specifically, of course, then it's fair game, and it comes in through the third party witness, Officer Ferrara. However, it wasn't asked, and I just kind of want to get back to the kind of the subtle distinction between, the statement she makes, I didn't say, or the difference between I saw him produce a knife. Okay, so that's direct evidence that Mr. PHINIZY's in possession of a knife, and then there's a stabbing thereafter. Whereas, and I was trying to get to the point of where she says to the officer, Mr. PHINIZY stabbed the victim. That can be argued that she didn't actually see him do that, but that she, this is just dramatic event has just happened. She knows that he's been stabbed, and she supposes that it was Mr. PHINIZY. So that's where I think the distinction is between the two statements, and why it matters that
It's because of your defense that it was somebody else who actually did the stabbing.
Right, because there were two people involved. Well, there were three people. There was the victim, there was the defendant, and then there was another person, another man, the defendant's brother, who was involved in basically a physical altercation. So the defense was that it wasn't proven beyond a reasonable doubt that it was the defendant rather than this other man who was involved, who did the actual stabbing. The victim wasn't able to say who stabbed him. The knife was not recovered.
Mr. St. Lawrence?
Yes.
You can, at trial, defense counsel objected to Officer Ferrara's testimony about what Sylvie told him was not admissible for impeachment purposes. But on appeal, you're arguing something quite different, that it's not admissible substantively as an identification. Is that correct?
That's right. The objection.
So wait. So
Of course.
this argument is not preserved.
We argue that it is preserved. And we recognize, and I think it's the reply brief, that this is not a perfect objection by any means. But we think it's sufficient enough to have put the judge on notice that there was no testimony about her seeing or not seeing Mr. PHINIZY produce a knife. So the judge, that was the basis of the objection, was, look, there's no testimony of that. And so that applies equally to the Herndon error, because that's the basis of the Herndon error, is that because, of course, yes, Judge.
But Herndon's something entirely different than impeachment.
It is, but I guess
then I had trouble. We all agree that it's entirely different. So how is it the same?
The basis on which the judge denied or overruled the objection on the impeachment, on the prior inconsistent statement, or was
what was the basis for the judge denying it? I thought because the judge recalled that the witness had actually said something about a knife.
Right. And so our argument is, if you bring the Herndon error to his attention on the same basis, that this third-party witness, Officer Ferreira, can't testify to this prior identification because it was not brought out on.
Right. I agree that the judge was mistaken about what he thought he remembered.
Yeah.
However, he's not in position to correct an error that's not been brought to his attention on another ground.
That's right. I guess our point is he's under this mistaken belief. So we know that because of the objection that was made, the timely objection that was made. So in these circumstances, even if the Herndon error is brought to the judge's attention, he's going to overrule it anyway because he misapprehended the evidence that came out during Sylvie's direct examination. He understands that she did say that she did not see Mr. PHINIZY produce a knife, but we know, going through the transcripts, that she didn't testify to that. She wasn't asked about that. All right, well, we'd be in the same spot anyway, I guess is the
regardless of the standard of review, there was an abundance of evidence that the defendant stabbed him. They got in a fight during the early morning confrontation. He was seen punching the victim. The victim's bleeding. He said he's been stabbed, and the victim's blood is on the defendant's sneakers and jeans. How is this mistake a problem, even if it is preserved?
We think it mattered because it's the only eyewitness. Well, we think it mattered for a couple of reasons. First is hearkening back to, I think, the exchange I had with Justice Vuono about this being the only direct evidence that puts a knife in Mr. PHINIZY's hand before chasing the victim. So yes, we have the identification, but again, I
want to ask you something about that.
Mm-hmm.
You keep emphasizing, and I understand this, that this was the only direct evidence of the defendant having a knife in his hand. Are you arguing that the prejudice goes to whether or not it was a knife that was used to do the stabbing, or is it that it goes to whether the defendant was the stabber?
The latter. It goes to whether.
Okay. So then, right. So that's what I think too. And so then I think Justice Meade's question is the one you need to grapple with, which is if it's a statement that goes to identity, in other words, we don't really care. The statement doesn't really add that much with respect to the object itself, but rather who wielded the object. Then you have to deal with all the other evidence, including the blood splatters. So
Right.
tell me how, would you mind just going through why it is that this, even assuming it was erroneously admitted, meets either test of prejudice, whether it was preserved or unpreserved?
Yes. So the blood splatter is very small blood splatter on his shoe and jeans, where we know there was a lot of blood lost by the victim in this case. The problem with that is we don't know about the other man. Okay, the other man is Timothy Daniels. He's pulled over with the defendant. We don't know what was on his clothes, on his shoes. That stuff is not collected. He's free to go. He leaves. So we don't know. The other thing is that there's no expert testimony that this is cast off blood that would be coming from a person holding a knife. So when there's a melee with these three individuals all in close proximity, a person that's not wielding the knife and that's not doing the stabbing can certainly get small amounts of blood onto their clothes. So that in itself, especially where you have the absence of collecting any evidence from the other man, Timothy Daniels, that evidence, in our view, is not that strong to show that Mr. PHINIZY was actually the person who stabbed.
You're saying it just shows his presence, is what your point
It
is.
shows his presence, absolutely, but it doesn't go so far as to show that he's the individual where these two men have equal opportunity, that he in fact was the person that
With only one having a motive, though.
right. Of course, we know that the second man without a motive got involved in the fight. So whether Mr. PHINIZY was losing the fight and this man took extreme lengths to protect his brother, or this other man who just had at 3:45 a.m. had a long night and was looking for some we just don't know, but certainly there's equal opportunity there.
Your time is almost up. If
Okay.
you'd like to sum up, you have 10 seconds.
Of course, the last point, I want to make it subtle, but there's a jury question that says, is a fist a dangerous weapon? So I think that at least shows that the jury was grappling with who did they prove beyond a reasonable doubt that Mr. PHINIZY was the stabber. Thank you.
Thank you very much. Johnson?
May it please the court, Tara Johnston for the Commonwealth. Good morning, Your Honors. So dealing first with whether or not the Commonwealth satisfied the requirements of Commonwealth versus Herndon, I think here we can safely argue that the Commonwealth did satisfy the requirements of Commonwealth versus Herndon, because the prosecutor in this case did not just ask Sylvie about whether or not she recalled speaking with the officers, which is what happened in Herndon. She actually asked her about the identification itself, and not just about the identification, but about many of the statements that she made to the officers, including whether she told them that she saw the defendant chasing the victim, whether she told the officers that she saw the defendant's brother chasing after the defendant to stop him, and whether the defendant stabbed the victim, whether she ever made any of those statements. And she said she did not recall making any of those statements. She also testified on cross-examination that the only thing she recalled was that, but of course this is cross-examination, was the defendant coming out and speaking with the person, and then the defendant maybe tried trying to break up a fight. So, but even in just the direct examination itself, the prosecutor asked her about any recollection of telling the officers about a stabbing, and she stated that she had no recollection of making any such statement. According to her, a recitation of what happened, according to her, she stated that the defendant was in a jovial, happy mood when he approached her that evening, and that there was nothing that would suggest to her, according to her testimony, even on direct examination, that the defendant was involved in the stabbing at all. So I think based on that, it's very different from the situation you have in Herndon, where the prosecutor just asked the witness, okay, do you recall having a conversation with the officers? The witness testifies no, and there's no further questioning about the identification.
If you don't need an exact correspondence between the question asked on direct and then the, impeachment statement you're trying to get in, you don't need an exact correspondence in terms of the language used. How do we then measure whether Herndon or Herndon, I don't know how you say it, is satisfied? In other words, how are we going to articulate whether it's come close enough?
And I think that is a difficult question. I think that's why the Commonwealth argues in its brief, assuming that Herndon was not satisfied, because I think the problem here is that Herndon does not state the level of specificity that it requires. So while it states that you have to ask about the identification, it doesn't say whether you have to ask about each specific question that the witness made to the officer. And I think that becomes a question of just common sense wise looking at the identification that the person was asked about and seeing, would that identification that she's denying having made include a basic denial of her having seen him produce a knife. I think it's clear from the identification that she's denying here that she never saw him produce a knife, because she's denying having made any statement identifying him to the officers, and she's denying on direct examination really having him seen do anything violent or anything toward this Lucas that would suggest that he was stabbing him or anything else. And
so is the test you're advancing that that we would somehow conjecture if what the witness would have answered had the question been posed?
I'm not what she would have answered, but I think it's clear from her answers on direct examination that she is denying having made that statement. For instance, in another portion of which she's asked on direct examination about when she sees, if she admits to seeing that the Lucas was stabbed, she actually says, after it happened, then I noticed he was stabbed. So I think that in itself is saying she did not see anything. She is stating she did not see anything. So I think there's a good argument here to be made that based on the identification, she is absolutely denying having made any identification. That requirement of Herndon is satisfied. But again, Herndon does not state the specificity. So according to my brother, and I can't say this is definitely not the case, what he's arguing is you must ask about Herndon requires that you ask about each single statement related to the identification that the witness was asked by each of the officers before that testimony is elicited through the officers regarding.
In your view, Ms. Johnson, could the witness been recalled in this case to be asked that specific question?
Your Honor, absolutely. And that's why even in Herndon, the court states, look, this is an evidentiary rule. It's not a constitutional rule. The reason for that is because the witness can be recalled. Really, it's just a matter of a procedural rule to get this out first through the witness. So there is absolutely the opportunity to do that. Also, I want to point out, as pointed out in the Commonwealth's brief, there's no contention on the part of the defense that the defendant did not have access, or his counsel did not have access to this information prior to trial. In fact, it's very clear from the motion for discovery this was part of a police report. There's no contention that it was not. It was in Officer Pereira's police report, and there's no contention otherwise. And that defense counsel had this when at the time he cross-examined the witness. And as a matter of fact, defense counsel, as I pointed out, did specifically ask on cross-examination, although he did not call Sylvie for rebuttal to call her back, but he did ask her specifically on cross-examination, or she asked her rather, sorry, she asked her specifically on cross-examination, what did you see, if anything, through this whole time that he did? And her response was, the only thing I saw him was maybe a fight break out, and maybe he tried to break up a fight. So I think through all of that, it was clear. But regardless, even saying that Herndon, even assuming that Herndon does require that level of specificity. First, the Commonwealth would argue that the standard to be applied is the substantial risk of a miscarriage of justice standard, because the defendant did not preserve the issue by arguing that the evidence should not come in for a different reason. In Herndon, if we look at Herndon, we see that the defense counsel in Herndon, actually the basis for his objection was this shouldn't come in as part of a substantive identification.
Right.
It is not that it should not come in as impeachment evidence. He actually argued the only reason this is admissible is for impeachment purposes, and assuming he would have liked instruction to that effect. Here, the basis of this objection was that this shouldn't come in as impeachment evidence, but certainly it should have. This was definitely an inconsistent statement with her direct examination testimony. It certainly could have come in for that basis, and there's no contention on appeal to otherwise. So really what my brother is asking—
What do you say, Ms. Johnson, if I may ask you about the fact that the judge did misapprehend the evidence? He believed that that there had been direct testimony with respect to from Sylvie about producing a knife, and that was not the case.
Well, so I think there's two things here. I think one, we can't really look to when we look at whether an issue is preserved, we don't really look at the underlying facts that the judge based his decision on to determine whether or not the objection is preserved or not. We look at the basis for the objection. Here it was that it was impeachment. But even looking at the underlying facts, we don't necessarily know if Herndon or that had been brought to the judge's determination, to the judge's awareness that he would have made that same determination. And that's because the judge, we don't even know how the judge is looking at the evidence. For instance, he's saying, I believe that she did testify to that. Now, the judge may have been looking at it from the perspective of, well, looking it back at what she did testify in direct examination. Oh yeah, she said she never saw anything happen. She didn't see, there was no stabbing. Okay, she did testify to that, to the extent that this is admissible as impeachment evidence. So it was not brought to the judge's attention. Okay, well, it was, to the extent that defense counsel said she never testified that he didn't produce a knife, but it's not brought to the judge's attention to the extent that, okay, well, he must testify under Herndon to this specific statement that she made to the officer in order for this identification to come in through the officer under Herndon is a matter, it's a new procedural rule set forth in Herndon. Now, I'm not saying that a objection has to be so exact or so precise or you have to use some magic words, but you have to at least let the judge know the basis for the objection. Here, there's no question that on the basis of the objection that was made here, that testimony was admissible through Officer Ferreira, that she saw him produce a knife on that impeachment. On that impeachment basis. Really, the only issue here is whether or not it properly comes in as a substantive out-of-court identification, and whether or not you need some limiting instruction. And that was not brought to the attention of the judge. And the Commonwealth would suggest that in order for the issue to have been preserved, that would have had to have been brought to the attention of the judge. I don't think there's any case that says that in a situation like this, where there's a completely different basis, a ground for arguing that the evidence shouldn't come in, the issue is preserved. But regardless, even whatever standard you look at, the evidence here was overwhelming, and there's really no argument here that the defendant could have gained anything from that question having been asked to Sylvie Goncalves based on the questioning that was asked and her responses. My brother's argument, I know, is, look, maybe it was the brother who did it. And there's several problems with that argument. I think one, as this court points out, there was blood found, the victim's blood found on the defendant's shoes and jeans. But even aside from that, we have the victim testifying. One, we have a motive. Two, we have the victim testifying that Sylvie is there pretty much when he's stabbed, that she's running after him. So even though, according to Sylvia, what Sylvia testifies to, she only sees him after the stabbing, we have Lucas testifying, she was there, she's running after us, and I'm trying to get her away from me to stop the defendant and his brother from chasing after me. So it's clear that she is there throughout this. What's also clear is that she tells Officer Siarka, and my brother is not contending on appeal that this should not have been admitted in any way. She tells Officer Siarka that not just that that the defendant stabbed the victim, she tells him that he chased the victim and that the brother was chasing after the defendant to trying to get him to stop. That was admissible. That was coming in no matter what. My brother doesn't argue otherwise. So that's clear evidence that it was not the brother. Between the blood, the motive, and her identification to Siarka that it was the defendant who stabbed Lucas and that the brother is trying to stop him from doing so, I think it's very clear here that the evidence was overwhelming that it was the defendant.
And you say that part of her testimony came in substantively in your view?
Absolutely, absolutely.
So
So
part of the identification.
Absolutely. So even if you take away Officer Ferreira's testimony completely, here we have Officer Siarka's testimony, which there's no question about. And also, even if you look at Officer Ferreira's testimony, my brother isn't arguing that that identification should not have come in. It's just really that one piece about producing a knife. And I think that when you look at all of the overwhelming evidence together, even if you take out that one piece of the testimony, it's just not clear how that could have at all prejudiced the defendant. Additionally, as this court has pointed out, the defendant was free to call the witness back to testify about that. He chose not to, and really there could have been nothing gained from it. So for those reasons, the Commonwealth asks this court to affirm the defendant's conviction. If there's no other questions from the court?
No, I see no questions. I want to thank you both again for participating in this way. And on behalf of the panel, we hope that you stay safe and healthy and that your families are staying safe and healthy.
Okay, we are live streaming.
Okay, good morning. On behalf of the panel, I want to thank both of you for participating in our argument this morning in this remote format. We promise that if you have technical difficulties, we'll be patient with you, and we ask you to be patient with us if we have any technical difficulties. So far, the morning has gone smoothly, and we don't anticipate any. The same rules of oral argument that apply in the courtroom apply here on this format. You both know you each have 15 minutes to present your argument and that there's no rebuttal in the appeals court in Massachusetts. The members of the panel today are Justice William Meade and Justice Gabrielle Wolohojian. My name is Ariane Vuono. I'll officially call the case as Como versus Mark W. Is it THIBEAU or THIBEAU?
I believe it's THIBEAU, Your Honor.
THIBEAU, 2019-1339. Okay, Counselor, you may begin.
Thank you. Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking this court to reverse the lower court's decision dismissing the count of witness intimidation for two reasons. The first reason why that decision was error is that the judge strayed beyond the four corners of the application for criminal complaint when assessing probable cause. The second reason is that the judge erred by not interpreting the facts included in that application in the light most favorable to the Commonwealth. Beginning with what was contained in the four corners of the application for criminal complaint, it was clear both that there was an ongoing criminal case involving one of the Chaparro brothers as a victim. And it was also clear that the defendant knew about that ongoing case. The Chaparro brothers, on their way to 10 Metcalf Circle, encounter the defendant and tell him that they don't want trouble before court. The defendant calls them snitches, a reference to police involvement and ongoing court proceedings. And then the defendant references the prior beating that was the basis of the ongoing criminal case by saying that they ought to fight fair with Manny, the defendant from that first case. The judge's error here was in finding that there was what she called, quote, no process being issued. And from that, concluding that there was no ongoing criminal court case. The error here is that in the narratives, the 3 narratives that were included in the application for criminal complaint, it includes the statements from the victim to the defendant's statement, and the fact that there was an ongoing case, and that's in the appendix at page 17.
Now, I'm assuming that the show cause in front of the clerk's office had already been scheduled.
It had been scheduled, yes, at that time. Turning to the judge failing to view the facts in the light most favorable to the Commonwealth, in addition to the clarity of the court involvement that happened at this time, the defendant called the Chaparro brothers snitches and then proceeded to beat one of them with a tree branch. The connection between the court case and the violence is certainly a reasonable inference to be drawn from the application for a criminal complaint. The judge erred by divorcing the use of the term snitch from the violence and commenting that the use of the term snitch did not rise to the level of intimidation. This was error both in terms of her interpretation and the elements of the witness intimidation statute and the way that they'd be applied.
Okay.
If there are no questions.
The facts of the case are pretty straightforward. So,
Yes.
And you can be assured that we've reviewed everything you've given to us. It was, as far as reading goes, we've read the complaint, the push report. So don't be taken back by the fact that we don't have a lot of questions. We have reviewed the file. But before you sign off, I'll just double check with Justices Meade and Wolohojian to see if they have any questions.
Just one very brief one. You said that she strayed outside the 4 corners. When did she do that?
So she ruled that no process had been issued at that time. In doing so, she was looking through other court papers to find out that a clerk's hearing had been scheduled at that time, but the narratives included in the complaint included the facts that there was an ongoing case involving one of the Chaparro brothers as a victim.
Thank you very much. I get it. Yeah, that's all.
Okay.
Thank you very much.
Thank you very much. Okay, Attorney Flaherty.
Thank you. Members of the panel, may it please the court. My name is Attorney Flaherty and I represent the defendant appellee, Mark THIBEAU. Your Honors, the motion judge was correct in her findings that in order to allow our motion to dismiss the intimidation charge, because there is no probable cause to support that charge. And although probable cause is a low standard, there still is this minimum standard that must exist to prevent unfounded prosecution against our citizens. It must be more than a mere suspicion. It must be reasonable, trustworthy information sufficient to warrant a prudent person in believing that the defendant committed this offense. Your Honors, in terms of the elements of the intimidation of a witness statute, it is a broad statute, but here the facts don't add up to probable cause for intimidation of a witness. The purpose of the statute is to protect witnesses from being harassed and therefore reluctant to participate in criminal investigations and criminal prosecutions. It prohibits the threatening and the intimidation with the intent to interfere with the investigation or a criminal prosecution.
May I ask you a question?
Yes.
This is just hypothetically. Let's just say that the victims here had shown up as they did and announced that they were there to speak to the person who was going to be a defendant in the earlier, with whom they had the earlier conflict, let's just call it that, and said they wanted to talk to that person before they had you know, before the case went to court, which is sort of what they said, right?
Yes, Your Honor. I believe, according to the four corners of the police report, the defendant, all of these people live in the same housing complex. You know, as you mentioned, Your Honor, my client left his house at 9 a.m., bumped into the two Shapiro brothers.
And the Shapiro brothers said what exactly?
So the Shapiro brothers, according to the police report, which my client denies, but we have adopted the facts as stated in the police report. According to the police report, my client walks by them and says, "You snitches, why don't you fight fair and square with my friend Manuel?"
Right, but
one-on-one.
One-on-one.
Didn't before then the Shapiro brothers, one of them say something?
They wanted peace with them, they want to make peace?
They did not, I don't think that they said that to my client. I think they said that to the police, that was their explanation. And I think that what happened first, according to the police report, is my client called them snitches. But I would submit to the court that there's nothing to connect my client, Mr. THIBEAU, with that earlier incident.
He refers to the incident.
The first incident that happened in January. And this incident,
Miss Flaherty, he refers to the prior incident.
He only says, Your Honor, he says, "You snitches, why don't you fight fair and square one-on-one?" So he knew that an incident had occurred, but there's nothing to show that he knew that there was going to be a clerk's hearing in March.
No, but he knew
why
that
did he use the term snitch?
I mean, by using a snitch, right? He knew that they had reported it to police.
He knew that it had been reported to police, yes. But there's nothing to show that he knew that there was going to be a further prosecution or a clerk's hearing coming up in March. That was stated in the police report after he had already said made the statement, the snitches statement.
THIBEAU and Reynoso are friends, correct?
THIBEAU and Reynoso are friends. They all live in the same housing complex. But importantly, Your Honor, I would argue to the court that they're not related. All of these men live in the same housing court.
Why isn't it a fair inference when he calls them snitches and tells them to fight fair, implying fight him one-on-one rather than going to court? And then when they refuse that, he beats him with a tree limb.
Well, Your Honor, first, I know that we are adopting the facts as stated in the police report, but as I noted in my brief in a footnote, that we do have a video to show that there was never a beating with the stick.
That could be brought up at trial, right?
It could be, yes, Your Honor, and that is more appropriate. But Your Honor, I think the motion judge was correct when she determined that those were two separate things. In terms of the intimidation, when my client bumped into the Shapiro brothers, it was 2-on-1. Daniel was there and Frank was there. Now, Daniel was the person involved in the first incident, Daniel and Mr. Reynoso Tejeda. Daniel and Frank are standing right next to each other. It's a stretch to assume that my client was trying to intimidate Daniel, who is the actual witness.
And yet in the legislature's wisdom, they included victims and family members of victims.
Yes, Your Honor. And that's, I believe, why the police decided to issue the complaint. But I believe that it's not a reasonable inference that a person would have the intent to intimidate someone by choosing the non-witness to hit instead of the actual witness. There's no connection between Frank Shapiro.
One could actually draw the exact opposite inference, that one would be more concerned if harm was to befall one of their family members rather than themselves, who they could care less for.
Yes, Your Honor, but I believe that the facts here don't add up to that, Your Honor. I believe that a fight between people, but a fight between two men does not rise to the level of intimidation of a witness.
But it
I would
wasn't just a
submit-
fight, though, was it, Ms. Flaherty? You're divorcing the incidents the way the judge did, which doesn't view it in the light most favorable to the Commonwealth.
Well, Your Honor, respectfully, I would argue that the two incidents are separate incidents.
But is that in the light most favorable to the Commonwealth?
I believe that it is, Your Honor. I believe that it's just not a reasonable inference to believe that the defendant would strike a non-witness when he's standing there outnumbered. It wasn't an intent to intimidate, it was a fight. And Your Honor, I would also just add that the charges here, Mr. THIBEAU was charged with assault and battery, dangerous weapon, and I believe that that's the appropriate charge here. And we disagree that this even happened, but looking at the four corners of the police report, that's the appropriate charge. Now,
can I ask you another question?
yes.
I hope you'll concede that the judge's belief of the necessity of an extant criminal proceeding isn't necessary for an intimidation charge.
I do concede that, yes, Your Honor.
Thank you.
But with looking at all of the circumstances here, Judge, the time, place, and circumstance of all of these facts are important. And this charge of intimidation of a witness was an afterthought by the police. Now, Mr. THIBEAU was charged with assault and battery, dangerous weapon on February 15th. And it wasn't until April 2nd when we went to court for the pretrial hearing for the assault and battery, dangerous weapon that suddenly there's a new charge of intimidation of a witness.
I don't understand how that's relevant. I mean, I read that in your brief, and I quickly assumed that those police officers spoke to an assistant district attorney who reviewed the police report and decided, you know what, there's more here than just ABDW.
Your Honor, I would respectfully disagree. I believe what happened was that when the complaint was issued on March 26th for the charges against Mr. Reynoso Tejeda, a completely unrelated charge, not involving my client or the victim here, when that was issued, 2 days later, the police went into West Roxbury Court and took out an additional complaint against my client on March 28th. So 2 days after that complaint against Reynoso Tejeda was issued, they took out the intimidation. In my interpretation, that was the trigger for the intimidation of the witness.
But even so,
Is
doesn't
that
it make-
inside the four corners? Of the police
I
report?
believe it is part of their application for a complaint. They,
No, your theory.
Your Honor, it's part of the police's application for complaint for the intimidation of a witness. They had attached Mr. Reynoso Tejeda's police report, and then the police report involving this case. And all of the dates are right there, that March 26th, the hearing occurred, and then March 28th, they went into the clerk's office without a hearing and just had presented that to the clerk and had those charges issued against my client.
But as long as the statute of limitations hadn't run on the intimidation charge, why does it matter?
Your Honor, it only matters, and obviously, yes, Your Honor, I believe it only matters as the full picture here, as all of the timing, the circumstances, everything adds up to the fact that this charge is not appropriate. It does not rise to the level of probable cause. And in the appropriate charge is assault and battery, dangerous weapon, not the afterthought of the intimidation, which was triggered by the complaint it being issued in an unrelated case. And Your Honor, if I may have a moment just to review to make sure I didn't leave anything out.
Sure.
Thank you.
Go ahead.
I believe at this point I'll be concluding that
Okay.
Unless the panel has any other questions.
No,
And I would just,
you're nearing the end of your time anyway, so if you have anything else you'd like to say, fine. Otherwise, you're welcome to rest on your brief.
I'll rest on my brief. Thank you
You
very
both
much.
did a very nice job. Thank you very much for bringing both your briefs and your argument. On behalf of the panel, we just want to wish that you stay safe and healthy and your families.
All right, we are live.
Okay, good morning, Attorney Spofford. Thank you for participating on your argument today in this remote format. We may have some technical difficulties. I hope not. We've had none so far this morning, but if we do, we hope that you'll be patient with us and we will be patient with you. You're the only person arguing today, as you can't see, but you can know virtually. And so of course, you have 15 minutes to present your case. The panel today consists of Justice William Meade, Justice Gabrielle Wolohojian, and myself, and I'm Ariane Vuono. I would just like to remind you, I'm sure I don't have to, that the case is impounded and that therefore you should only use the term juvenile for your client, all right?
Yes, thank you, Your Honor.
Please go ahead and begin.
Members of the panel, may it please the court. My name is Sarah Spofford and I represent the juvenile in this case. In this case, the court clinician said, what's been tried hasn't worked. And what had been tried was involuntary commitment. And yet that's exactly what the judge again ordered. And her order must be vacated for two reasons. The first reason I'll discuss is the sufficiency of the evidence of a likelihood of serious harm resulting from my client's alcohol use disorder, beginning with the hearsay issue. And I will then turn to less restrictive alternatives. There were two problems with the hearsay in this case, each of which requires that the order be vacated. First, the judge was required to make findings as to the specific indicia of reliability of any hearsay relied upon in the commitment determination.
Can you please identify for me the specific hearsay statements that came in?
Yes, Your Honor. Specifically, I'm referring to the court's reliance on the history, my client's history of hospitalization.
I understand that. That was something that came in through a live witness at trial. I didn't see that the live witness at trial said that someone out of court said something.
Yes, Your Honor. And so the inference is that they must have, because the live witness, the petitioner who was my client's mother, had no personal knowledge of the period between September or October of 2019 when her child went into the custody of the Department of Children and Families, and early March of 2020 when the child was returned to her custody.
Well, I don't know. I didn't see that in the transcript. What I saw in the transcript was that the child wasn't in her custody, but I didn't see anything that said she didn't know what was going on.
Well, Your Honor, I would specifically refer the court to the mother's frustration that often hospital records went to the Department of Children and Families, and so she was unsure what happened.
Right. So I hear you that like she wouldn't be able to testify to, for example, the contents of the medical record, because the medical record might be hearsay, but she didn't do that. So she said, my daughter was put in the hospital, which is not a statement, a hearsay statement. I do understand your, but it's not really the primary thrust of your argument, I don't think. I do understand you to be challenging the foundation, her foundation, to be able to say that, like, how could she know that? But that wasn't challenged. And you're not challenging it now. But I don't understand where the hearsay statement is.
The hearsay statement that I'm referring to is essentially that she is alluding to hospital records and to out-of-court statements of DCF workers, and basically that she had no personal knowledge of the hospitalizations herself, and instead made conclusory statements about a pattern of hospitalizations, and that her daughter had been in and out 10 times without testifying as to the specific dates, hospitals, or as to her own visits on those dates. The judge made no findings as to the reliability of that history of hospitalizations as she was required to under the matter of a minor case. And additionally, the hearsay was inadmissible because it was not substantially reliable. The matter of a minor case also summarizes helpfully in footnote 8 at page 24 of the slip opinion, the factors that courts traditionally look to in determining the reliability of hearsay as identified in the Durling and Abade line of cases. And there courts ask, is the hearsay factually detailed as opposed to conclusory statements? Was there personal knowledge and firsthand observation, and is it corroborated by other sources? And unlike in Durling, where there were 2 separate police reports of very similar events by separate police departments, and where they got specifically at facts rather than at legal sort of conclusory statements, unlike that here, the court's reliance on multiple prior hospitalizations, accepting the petitioner's estimate that my client had been in and out 10 times, there was really no personal knowledge for those statements because, again, between the period of September and October of 2019 and March 2020, her daughter was not in her custody. Moreover, the court clinic similarly had no basis because the clinician reviewed only the records of the most recent hospitalization on March 17th, which did allude to the hospitalization on March 8th, which I do not contest. But she, unlike the emergency room physician who had an opportunity to examine my client in person, both the morning of the hearing and the previous day, the clinician had the opportunity only to speak with my client for 10 minutes by phone. She had no opportunity to see her visually or to examine her physically to see whether she was displaying any signs of withdrawal or sweating or intoxication. Accordingly,
Was
the
the
record is
emergency room physician, I didn't think the emergency room physician was undertaking the exact same evaluation that the judge is undertaking here. Is that correct?
Your Honor, my understanding is that Dr. Spire, the emergency room physician, was asked by, and this is at page 27 of the record appendix, the DCF worker and various staff members from the Department of Children and Families called the hospital in an effort to have my client sectioned, whether under Section 12 for suicidal or homicidal ideation or under Section 35 for substance use disorder, and that the emergency room physician opined that that was not appropriate based on the 2 March hospitalizations.
I thought that the reference in the medical records was only to Section 12.
Right. No, Your Honor, there was a reference to Section 12, but there is additionally a reference to Section 35.
And that's on which page?
That's at page 27 of the record appendix.
And the emergency room physician talked about that?
Yes, Your Honor.
Let's see, page 27?
Yes, and it's also at pages 19 and 20 of the hearing transcript where I questioned the court clinician on that same subject. And she basically said, yes, I opined differently. I'd like now to turn to the question of sufficiency, if that's all right. Even if the hearsay had—
Before you do that, sorry, it's so hard. So hard. I should raise my hand. I have one more question. I don't have any idea what the answer to this question is. It's a genuinely innocent question, not a trick question. These are civil proceedings. What is the standard of review if the issue you're raising on appeal was not objected to down below?
Well, I think for the hearsay issue, it's a question of constitutional dimension, as was made clear in matter of a minor. And so I believe it's for harmless error, but the error here was not harmless because much of the bulk of the hearsay relied upon was not reliable.
And the hearsay again is the statement that she was admitted 10 times previously?
That she had been in and out 10 times, and the multiple prior hospitalizations that the mother was basically saying as a well-intentioned statement, but as one with no basis or foundation.
Where
Yes,
is
Justice Meade.
is the juvenile been released?
She has, yes, Your Honor.
So this is moot, or
It
are
is
you
not,
be
it is
capable of
not, Your
repetition?
Honor. Under matter of a minor, these orders are no longer moot even after the confinement has ended because of the continuing stigma.
Because of the stigma, okay. It
And
would
also
probably be
because
capable
it
of
could
repetition.
provide a basis for future commitments, right?
In light of the time remaining, I would refer the court to my discussion of the sufficiency issue in my brief and continue on to the question of less restrictive alternatives. Even if there was sufficient evidence of a likelihood of serious harm in this case, which there was not, the judge erred in not recognizing that that risk was mitigated by the less restrictive alternative articulately presented by a 17-year-old desperately advocating for something better for herself than what had already failed. On the one hand were a set of options this young adult was eager to try and to proactively choose for herself that might actually get at the root cause of her pain and her alcohol use. Instead, the judge sent her back to a congregate care setting that had not previously worked during a highly contagious
Counselor,
pandemic.
can I interrupt you just for a moment?
Yes, Your Honor.
Even from the transcript, certainly you could see that your client was very articulate and wanted to make her point and known to the judge, which I think the judge responded with some compassion. But what the judge pointed out was, given the situation, given the pandemic, many of the alternatives that your client was speaking about were not going to be available to her. And the judge made that very clear that those alternatives were not going to be available. And that, it seemed to me from the transcript, really, and also from her findings, was a main factor for making the decision that she made. So what do you say about that?
Your Honor, to that I would say that for Section 35 to be constitutional as applied, the court must find by clear and convincing evidence that there are no less restrictive alternatives. But for an alternative to be appropriate, the matter of a minor court made very clear that it need not eliminate all risk and that it need only be viable and plausibly available. And I think where we prevail here is on the plausibly available phrase, because although this was early in the pandemic, we are having an appeals argument right now via Zoom, and things evolve and society shifts. And I think even on the date of the hearing, it was clear that these alternatives remained available. My client had been in FaceTime contact with her therapeutic mentor that very day from the hospital. And we also know that the group therapy that she was engaging in with her peers consisted of only 4 to 5 other girls. And so even had it occurred in person, that would not have violated the governor's ban. And so it was plausibly available.
One of the things that struck me was that your client stated a couple times that she was still in school and she was still doing things that the judge knew for a fact were no longer occurring. What inferences do you think the judge could draw from the fact about the client's willingness to actually engage in these therapeutic alternatives, even if they were available? What inference do you think the judge could reasonably draw from the fact that your client was not forthcoming and not truthful about what she was actually engaging in?
Your Honor, I read even the court's conclusion to be different there. I think that the court's point about school closures was that there was confusion and ambiguity as that week everything was essentially closing down. But I think the most important piece here is the piece that had never been tried, which was individual therapy, one-to-one therapy. The petitioner, both in her petition and in her opening testimony, identified serious depression as one of my client's main issues. And my client identified her substance use as secondary to her primary mental health issues, which were exacerbated by the recent violent deaths of 2 friends. She was highly motivated to engage in individual therapy and had a confirmed appointment 2 days from the date of the hearing. And there was every reason to believe that she would engage in it. Although the judge found that she had run from a previous hospital placement in January, that was unreliable because it was very unclear even from the court clinic's testimony as to why she had been there in January. But even if she ran from involuntary medical treatment, that really says nothing about her willingness to engage in one-to-one individual therapy addressing her underlying trauma for the very first time. For that reason, the order was unconstitutional and must be vacated. I should add only, as I see, I do have a minute left, that the less restrictive alternatives must particularly be considered in light of the fact that even at this early stage in the pandemic, the juvenile court standing order made clear that the priority needed to be getting kids out of group settings rather than sending them back in. And so that does need to be a factor in considering the risk to the child of entering a group setting at that time.
Okay. Any other questions from the panel? I see none. Okay. Thank you very much, Attorney Spofford. We appreciate your argument. Well, on behalf of the panel, I just want to say we hope that you and your family stay safe and healthy during these challenging times. All right.
Thank you very much, Your Honor. The same to you.
We've had absolutely no technological glitches. We don't expect any now, but if we do, we expect your patience. And I can tell you that if you have any problems, we will be patient with you as well. The same rules of oral argument apply on this format as they would as if you were in the courtroom. One of you is virtually in the courtroom right now, and that is 15 minutes per side for your oral argument, and there is no rebuttal. You can be assured that we've gone through the record that you've submitted to us carefully, so you can get right to your arguments. The panel you have today is Justice William Meade, Justice Gabrielle Wolohojian, and me, and my name is Ariane Vuono. With all that said, we can start. I think it's still morning. Yes. The name of the case is Victoria Juan versus Cohasset Conservation Commission, 2019-0968. Counselor.
Good morning. May it please the court. My name is Matt Mitchell from Tully Rinke PLLC in Buffalo, representing the appellant. I would like to thank the court for hearing this appeal in these very difficult circumstances. In this case, the town of Cohasset is asking this court to adopt a position that the commission is not required to render a decision at any time under the stormwater permit application. This flies in the face of the rules of statutory construction, and as the court stated in the Martha's Vineyard Land Bank case, this would lead to an absurd result. It would leave my client with absolutely no remedy other than seeking the assistance of the courts to request a decision, as we do here, to either find constructive approval or that the commission has lost its right to insist on the standards in the bylaw, or that it has no jurisdiction. If the commission did make an adverse decision, then Mrs. Juan does have the remedy of challenging that through a certiorari action in the Superior Court. Now, I understand that I rely in part on cases involving disputes under statutes which have constructive approval provisions. The reason behind this is that there are no decisions which address the specific issues raised in this complaint. While these cases are distinguishable, as my brother has aptly pointed out, the statutory construction and public policy considerations expressed by the court in those cases are directly applicable to Mrs. Juan's case today.
So you say that they apply by analogy, basically, is your point?
I do, Your Honor, because really, I could not find anything else that directly addresses this particular situation where there's no constructive approval, but as we contend, a firm deadline.
So pushing you off this argument for just a moment,
That's fine.
and it may be that my panel members would like to go back to it, but notwithstanding the decision that there is no provision to constructively grant approval here. What the Superior Court judge has said and what the commission says is that really by your own action, that's why there's been no decision in this case, that you actually asked, your client actually asked to reopen the hearing. The hearing was reopened. I think we can assume that at the hearing there was questions asked that may have indicated that there was going to be more problems than anticipated. Then the decision came down from Judge Miller saying that that order of conditions from the wetland provisions had to be approved. and then you decide to go to court rather than ask for a decision on your stormwater application. What do you say about that?
Well, I knew you were going to ask that, actually.
Really?
Well, when the engineer went in to reopen the public hearing, the commission actually raised the same exact issues that they raised in the wetlands case, some of which do not fall under the stormwater permit bylaw at all, such as plowing the driveway. They wanted my client to retain an expert at cost to her to review the project. And there was no guarantee that the commission would make a decision within the 21-day period anyway, because that's why we're here today. And they still haven't made a decision. You know, given the wetlands dispute that was pending in the Superior Court, our thinking was that if they did actually make a decision, it would be a denial, essentially backfilling the mistake they made in the wetlands case. So we felt that it was a fait accompli that we would get either a denial decision or no decision whatsoever. And we felt that because the permit after the public hearing was waiting before the commission for 18 months before my client went back in. So in a period of 18 months, they had that application in front of them and still decided to do nothing with it.
But
So-
the record, well, that's just two questions. I guess what your reasoning was is not really part of the record, although I appreciate the context. But is it fair to say that when you went in and asked for the stormwater application to be reopened, there was no request at that point? 18 months have gone by. Please give us an answer with respect to this application. Correct?
That is true.
Nothing in the record that says that happened. Is that right?
Yes, you're absolutely right.
Justice Wolohojian has a question. Hold on.
Okay.
What was if the stormwater application had already been constructively denied, what would be your authority for being able to reopen a hearing on that?
We actually wouldn't have the authority to reopen it. We would have to refile the application.
Okay, so then if that's the case, then how can we understand your effort to reopen the application as anything other than an indication that the permit had not been constructively denied before then?
Well, I understand that, Your Honor, but I guess the answer to that is that we believe, in terms of what the statutes say, what the cases say, that there was an actual constructive approval, or they lost the ability to insist on the provisions of their own bylaw. We did what we did in an attempt to try and shorten this up a little bit, but if you look at the end of the Conservation Commission minutes from the stormwater permit application hearing after it was reopened, the commission actually continued it until a decision was made on the wetlands appeal. When the decision was made on the wetlands appeal, and again, not in the record, but our feeling was that we were comfortable with it. We knew they blew the deadline. And so what we were hoping is actually
Can I interrupt you for a moment? I'm sorry. You knew they blew the deadline originally, not the deadline from the time that you reapplied, correct?
I agree, but I was actually talking
Just
about
want to be sure I understood you.
You did, but I was talking actually about the wetlands permit application, because the commission continued the hearing, the stormwater permit hearing that was reopened, until the commission, the court made a decision, the Superior Court made a decision on the wetlands appeal. And we felt comfortable with the wetlands appeal. We felt that they blew the deadline, which Justice Miller found that they did. She indicated that the project could go forward. DEP had issued a superseding order of conditions. We were in good shape, and we felt that because the stormwater permit requirements were in the plan, there was only one plan submitted, and that is the plan is not actually in the record, but the reference by Greg Morse of Morse Engineering indicates that the stormwater permit structures were in the were in the plan, because one plan was submitted for both. There wasn't a separate stormwater plan and a separate wetlands plan. There was only one plan. So we felt if we went back to the commission, that there would be an opportunity to resolve this, because the protections for the stormwater were already in the plan and we're obligated to do the entire plan. The as-built has to be the plan, or we don't get a certificate of compliance from the commission or the DEP. So that's where we were at that point in time. But I don't believe that that changes the fact that going back to the original 21-day deadline, that gets the commission off the hook for sitting on it for 18 months, forcing my client to come back to them. I mean, it kind of turns the responsibilities of the parties on their head. The commission doesn't follow their own bylaw deadline, thereby flipping it back to my client to come back again, pay her engineer again. They ask for an engineer to be appointed. And it just, in any sense of equity that I've ever seen, it's completely unfair, completely unfair.
So just so I'm clear, you just explained to us that the two applications were presented together within the same plan and same design.
Yes.
No question that the wetlands portion of the plan was rejected, right? So what you're saying is that there should have been a separate decision within 21 days, within that period of time. Well, they were late on the wetlands one as well, but there should have been a separate decision for the stormwater application, that it could not be considered together as they had actually been presented.
Well, the practice has actually been different, and there is a decision that I attached to the complaint in this case, where there's a stormwater section that is discussed, and in that particular case. However, in our case, the denial of the order of conditions, the reasons that the commission set forth did not address stormwater at all.
Yeah. Okay. Okay.
I'd like to go to Justice Gilday's decision, if I may, in his interpretation of the Zuckerman case, which was a 40A Section 15 case where the ZBA blew the deadline for a 14-day deadline after it made a decision to file the decision with the clerk of the town. The Justice Gilday interpreted that decision as saying that as long as, and in Zuckerman, the ZBA made the decision within the 75-day period, and the 14-day period fell within the same period, fell within the 75-day period. So his reasoning was that the failure of them to meet the 14-day deadline did not go to the essence of the thing to be determined. But Zuckerman then distinguishes a case called Capone, where the ZBA in that case issued its decision within the deadline that they had, but didn't file it until 35 days after the deadline was blown. And the court says in that particular case, and Zuckerman says in that particular case, that goes to the essence of the thing to be done. The final step so that the person could get the permit or not, and have a remedy if they did not, or go ahead with the project if they did. So he essentially, Justice Gilday says, the Capone, I'll just back up. The Capone, or Zuckerman said at the end, it said, the SJC stated that the failure to meet the 14-day deadline created the prospect of a perpetual cloud on the rights of a landowner to use his land. In Justice Gilday's decision on page 37 of the record, page 37 of the appellant's brief, he erroneously finds that the word shall is directory in this case, and the 21-day decision deadline does not go to the essence of the thing to be done, which is contradictory to the holding in Zuckerman and Capone. Here, the requirement in the bylaw that the Concom shall issue its permit denial determination in writing within 21 calendar days after the close of the public hearing goes to the essence of the thing to be done. The decision on whether to issue a permit or not is the end game in a stormwater permit application. So it has to be the essence of the thing to be done. And so Capone held, if you don't meet the essence of the thing to be done and leave a landowner hanging with no particular knowledge of what their rights are or not, then that is a flaw in a permit to get a permit to be constructively approved, even though there was a provision in that particular statute. which provides for constructive approval. So again, our case kind of falls in between or completely out of these types of cases, but the reasoning really is the same, because the decision is, as I said before, the ultimate. I mean, that's what Mrs. Vuono was going for, and she didn't get it and was forced to come back. And
if we were to agree with you, can you spell out for me what the practical ramifications are going forward? At this point, you would be deemed to have constructive approval of the stormwater permit.
yes.
And where does the rest stand?
Well, the notice of intent went up to the DEP for a superseding order of conditions, which they issued, saying that the project completely complied with the Wetlands Protection Act and its regulations. So that permit is in place, and there are requirements that come out of that permit. One of which is that the project has to be built according to the as-built plan that's on file. The as-built plan that's on file has the stormwater structures in it. So practically speaking, if the commission had granted the permit, then the stormwater protections are in there. They're already in there as it stands now. And after the project is built, DEP and the commission come back. They come back and look at the project to see if it was built exactly according to the plan, in order to give them a certificate of compliance. Plus, if the project is not built in accordance with the plan or anything happens thereafter, the town still has enforcement authority under DEP. The DEP has it as well, but DEP has delegated that.
So and now let's take the converse. If we were to rule against you, the practical effect is what? It's without prejudice, right?
I'm sorry, Judge, what was that without prejudice?
If we were to rule that your subsequent reopening of the hearing sort of reset the clock, or however you wanted to phrase it, and you did not have constructive approval of the stormwater application, where would that leave you and your client now?
That would force her to go back with her engineer to the commission.
To the commission.
Which again, I explained earlier that we have a pretty, I think, educated opinion that the commission, because of losing the wetlands case and doing what they did during the first hearing, raising the wetlands issues again, asking for a third-party engineer, which is going to cost my client a lot of money, we just felt that we were going down the road to another denial, which we would end up back in Superior Court under a certiorari case on the merits of whether the denial and the environmental protections that my client is providing were sufficient or not.
Okay.
So we're back to square one, I
Okay.
guess, is where we would be.
Right. Well, your time is up. Thank you very much. I'm just going to check with the panel to make sure that there's no further questions of you before. No, none. Thank you very much, Attorney Mitchell. Appreciate it.
Thank you very much. Appreciate it. Stay well.
Yes. You stay here now. You're not going anywhere yet. Okay. Attorney Deutsch?
Yes. Good morning. Good morning, Your Honor, and good morning to all of you. I hope that you and counsel and court personnel are well in these difficult times.
Yes,
I do appreciate the opportunity to address the court, albeit virtually this morning. Your Honors, this is an unusual case, unusual both from a policy standpoint and factually in terms of the record. This court and the Supreme Judicial Court have made clear that constructive grant, even where it is mandated by statute, as it is in 40A, 40B, 11131, Chapter 41, is a heavy penalty subject to close scrutiny by the courts. And it's that scrutiny that Justice Gilday brought to bear, we think, appropriately in this case. The relevant bylaw here does not mandate constructive grant. It does not address it at all. And so the question whether to impose constructive grant here turns heavily on matters of policy, as well, of course, is the language of the bylaw. Its primary policy sought to be implemented, its primary purpose, and the facts of this case. And
What's the point of having the deadline for issuing the decision?
well, Your Honor, it is in part precatory. That is,
Well, it doesn't use precatory language.
indeed, it does not, Your Honor. Counsel asked and the court inquired about the implications of going forward here. It's a two-part process with regard to wetland and stormwater permitting at the local level. Denial of the wetland permit through denial order of conditions effectively ends the prospects for the project unless and until that determination is set aside. It ultimately was set aside, and in the meantime, there was an administrative appeal by the applicant to the DEP, which issued a superseding order of conditions. There is no such provision. That is, there's no parallel or independent review of stormwater by the DEP in the context of a residential project, which is categorically exempt. And so, yes, the bylaw does call for issuance of a written decision within 21 days. I believe that where the commission had made clear its concerns with the project in terms of both stormwater and wetland considerations, perhaps mistakenly, perhaps inadvisably. Nonetheless, the commission undoubtedly felt that it had spoken with respect to the project in a way that was decisive. And we're faced now with this court's consideration, as the Superior Court did carefully consider, the question of whether in this circumstance where there is no mandate and no case law directly on point, whether it is advisable and appropriate for the court to impose a constructive grant.
May I ask, is your position that it was not necessary for the board to issue a decision within 21 days?
Well, Your Honor, it ordinarily may well have been necessary. It was not.
And you would agree that a decision did not issue in 21 days?
That is correct, Your Honor.
Okay,
However,
so let's say all right, so what is the relief where the regulation is not complied with, and who has that relief?
the applicant did come to court with regard to wetlands. The applicant did not come to court with regard to the stormwater proceedings by filing mandamus. Sorry, Your Honor.
You know what, I'm not going to cut you off. You're probably getting to it.
Yes, indeed, Your Honor. It was available to the applicant and incumbent on the applicant in this circumstance to come to court with a request for mandamus relief or declaratory judgment. She did so, but she did so only, as I believe you observed, more than 1 year after the application hearing had ended and after she had come to the commission, presuming its continued authority with respect to her application, to ask that the hearing be reopened.
You're saying that if the board fails in its obligation to issue a decision within the time required, it's the applicant's burden to go seek a mandamus to compel the board to do what it's required to do.
Effectively, yes, Your Honor. I think it's important in this connection to note.
What's the best authority for that?
Well, the Oyster Creek case, well, first of all, Your Honor, the Oyster Creek case speaks to some extent to this issue. It arose in the context of wetlands permitting, but the court there rejected an effort by the commission to reopen its hearing and an argument that effectively extended the period, 21-day period, for the issuance of a decision, distinguishing the prerogative of the commission from the prerogative of the applicant. Here it was the applicant who did have that prerogative, and albeit at a much later date, requested and actively participated in the reopened proceeding.
Did Oyster Creek say that the applicant, if the board has an act, the applicant is required to go seek a mandamus to get it to act?
Well, it's a practical consideration, Your Honor. That is to say, if the board doesn't act and the applicant insists upon a written decision, then the way to get it would be through a mandamus or declaratory relief. That's what the applicant did here, but the applicant did it here after depriving the commission of authority to act on the reopened application.
Well, that was long after the 21 days.
Indeed, Your Honor.
The subsequent reopening didn't step on anyone's toes within the 21-day period the board had to act, the commission had to act.
Well, that is true, Your Honor.
Yeah.
It was, however, inconsistent with the position taken now that the failure to act within 21 days deprived the commission of the right to enforce the bylaw, to rely upon the bylaw. There is, if I might, the Superior Court, as I'm sure the court is aware, drew an important distinction between the wetland and stormwater regulatory process here. They're hugely different, and that has implications for this court's decision. And those implications are clear from even the cases involving wetland constructive grants in the wetland context, such as Oyster Creek. The court in Oyster Creek drew special attention to and relied upon that distinction when it noted that there is a parallel proceeding in the wetland context at the DEP, and that a failure of the commission to act and an administrative appeal by the applicant to the DEP with a superseding order leaves the superseding order in control. That is the backstop that Judge Gilday drew attention to rightfully. Mm-hmm. And in the case of the stormwater permitting scheme, there is no backstop at all, because single family projects under 4 units are categorically exempt. So the practical implication of a constructive grant here would be, contrary respectfully to Council's statement, the practical implication would be that the stormwater and flooding concerns would not be addressed at all. I say that because although the project plans reflect the presence of some stormwater control structures, there is no authority or jurisdiction by either the CONCOM or the DEP to enforce them if they're not built in accordance with the plan, because the DEP superseding order specifically notes, as regulations do as well, that this project is exempt from state stormwater standards. It's purely a local enforcement issue. And so, as I say, those policy considerations and the conduct of the applicant herself with regard to reopening make this an especially bad case for this court to declare broadly that commissions with respect to stormwater permitting permits are constructively granted if they don't act within the 21 days. Here, the tension that one might expect between those two policies, on the one hand, finality of the administrative process, and on the other hand, the substantive implementation of stormwater controls are really not in conflict because of the applicant's reopening of the hearing, as was her prerogative and the commission's obligation. She then abandoned the process, depriving them of an opportunity to act on it. And as the court, in denying the motion for relief under Rule 60 noted,
so let me ask you,
it's free to go back to the commission.
A question. So in your view, what should have happened here was after the Superior Court rendered a decision in Juan's favor with respect to the wetlands, a piece of that application, what she should have done then is just then bring another action seeking the commission to act upon her application, her stormwater application that had been filed about 18 months earlier, rather than reopening the case.
Yes, or Your Honor, have included in that wetland appeal an appeal of or an action for declaratory or mandamus relief with respect to the stormwater. She chose for strategic reasons not to do so, but instead deliberately to return to the commission, whose proceedings she, by implication at least, considered still to be open. That is to say, not having been finalized by a written decision or by the lack of a written decision, such that she could return and ask that the proceedings be reopened. There was substantive discussion. Her representatives were present. There was discussion of the substantive concerns, and in the course of that 1 hour hearing, ultimately, she opted to never mind or withdraw and roll the dice. The commission expressed during the original proceedings and during those reopened proceedings substantial concerns with the stormwater implications of this project. This was, as I'm sure that you've seen in the record, a project in which there was an somewhat elevated dirt and gravel driveway, 62 years old construction, running directly through vegetated wetlands and over an intermittent stream. And the commission had these abiding concerns and expressed these abiding concerns with subsidence, erosion, not just during the construction period, which was the only component of flooding subsidence might be addressed by the wetland scheme, but also post-construction. And in order to address those concerns, it was necessary that the bylaw provisions be implemented. Council has, in his brief, alluded to various other regulatory provisions, the Federal Clean Water Act and so forth. Those are respectfully a red herring because they have no application to a single-family construction project such as this. There is no regulatory backstop. And that's the policy concern here. I believe the court is confronted with a balancing, if you will, of the concern or policy with finality in administrative proceedings, which I submit respectfully is not implicated directly in these peculiar circumstances on the one hand, and the policy, the overriding policy of the bylaw, which is to protect the stormwater interests. I'd like to address, if I could, very briefly, a point made well, indeed, I think I've already addressed the points that were raised in the course of my brother's argument and the questions from the bench on that.
Okay. Have you concluded your argument, sir?
Yes, I have.
Okay.
Your Honor, for all of the reasons articulated in the brief and before you, there was no reliance on the original administrative proceedings as a final expression of the Commission's position with regard to stormwater, and constructive grant finality concerns are all about reliance. We would ask the court respectfully on the particular facts of this case to affirm the determination by the Superior Court to decline to impose a constructive grant of this permit.
Okay. Thank you very much. Thank you both very much for your arguments today. On behalf of the panel, we also wish you and your families, we hope you're all stay safe, stay healthy, take care of yourselves, and we'll take the case under advisement and again answer to you as